84. Welcome, welcome, welcome in, everyone. Welcome to Care Concierge with Care Patrol, where education is the heart of everything we do. We educate our clients about possible options for care and what is about to happen along their healthcare journey. We provide our advice to them at no charge. We're paid by providers in our system who provide assisted living or independent living or sitter services, but we work with other providers of elder law or home health or hospice services that we vet and recommend, and can work with you to work with your clients to choose services or provide advice, perhaps take something off your plate. That's Care Patrol, and we sponsor this. We educate our clients, and we're privileged and honored to be able to educate you today. As those of you know who've been with us before, we are accredited by the Alabama Board of Nursing and by the Alabama Board of Social Work Examiners, and each of these boards allows us to provide you with 1.0 contact hour for today's continuing education unit. In order to receive credit, you must do our online evaluation. This online evaluation is password protected. And in this way, the Board of Social Work allow for this hour to be considered a live hour or a classroom hour and not a video or recorded hour. If you want to see presentations like this one, which is being recorded, go to YouTube and type in Sean Barnes Care Patrol. We have about 130 or so continuing education hours available to you there to watch and take the evaluation and receive credit. And it would be pre-recorded credit to the Board of Social Work. Thank you all for being here. Hi, hello, thank you for speaking. For those of you that are coming in by telephone, I want to read to you our evaluation link so that you can make note of it. If you're ready with whatever device on which you make notes, here is the link, and I will post it shortly in the chat room. The link is https://www.surveymonkey.com/r/ all uppercase letters, C as in cat, Q, W, S as in Sam, 6, 7, C as in cat. And again, we give the password at the end of today's session. Looking for the link to be placed in the chat, Mr. Morgan, I just did, and I'm posting it again. The evaluation link is in the chat. We give the password at the end. For those of you that have joined us, I hope you remember, those of you that have been with us in the past, we very much appreciate and depend upon your discussion. I know that our presenter, Ms. Strickland, and I both value your observations, your questions, your outcomes, and anything that you may add to the presentation certainly adds to it for all of us. If you're not familiar with Zoom and the chat room, move your cursor to the top of your screen. A box should drop down. If that doesn't happen, move your cursor to the bottom of the screen. A box shall pop up. On that box is the word chat. Click there and add your questions and comments to Miss Strickland. And now, I'll present Pamela Strickland, who's a oftentimes presenter with us, who'll be presenting some difficult Medicaid case studies. And we're so pleased and happy to have you join us again. And I know that you prefer to be called Pam and
I
not
do.
Pamela and not Miss Strickland. And I'll try and remember to do that. Thank you for
I
being here.
appreciate that. Well, it's great to be here. Thank you so much. And I wanted to talk today about some Medicaid studies. And what that means is I've got three cases that are quite different, and some are quite detailed. And so I thought I'd go through those and show you the different types of Medicaid cases that we deal with and what the outcomes should be or will be. So the first case we'll talk about today is an 84-year-old claimant, and this claimant has been separated from his wife for 35 years, but they never divorced. And you'll find that happens a lot. There are a lot of older generation that they may separate and go their ways, but they don't believe in divorce. And so this is what happened here. This claimant doesn't believe in divorce, and so they've just lived apart for 35 years. This claimant had stocks and bonds in an IRA. So he is taking care of himself and been able to live on his own. Um, the claimant has actually helped his spouse, even though they don't live together, financially each month for years. He sends her money each month. And so we have to think about how Medicaid deals with this, because in Medicaid's eyes, if you have never divorced, I don't care how long you're separated, you're still married. They do not consider separation at all. You're either married or divorced or widowed. So, or single, of course. So this claimant and his wife are still married, even though they're not living together. And the odd thing is the spouse lives in Ohio in government housing. So she doesn't have a lot of money herself. That's why he gives her money. And she doesn't work. She has some ailments that keep her from working. So that is how it was presented to us. So when we talked with the spouse, we let her know what all we would need for the claimant and to let them know that they're considered married. And so we needed all of her financial information. And she cooperated and sent us everything that we needed. So we had to do some planning. And so, as you all know, if you've been in one of my seminars before, in Medicaid rules, you cannot have over $2,000 in assets to your name. So basically, we cashed all of that in, and so they had stock. He had stocks, and he had EE bonds, which are government bonds, and he had an IRA. And so we informed the family that these things had to be cashed in and placed into their bank account, his bank account, which they did. And then we placed these funds into the Alabama Family Trust. If you've heard me speak before, you know that there's been a skip of information here, and we'll get to that in a minute. So the spouse sent us all the bank statements requested. So we were able to look through her bank statements to see where he has sent her funds each month. So we filed Medicaid application, and we did ask for spousal support. The claimant wanted his wife to get spousal support, even though they haven't lived together in 35 years and she's in another state. So this was quite interesting. But if you'll notice that we never discussed splitting the funds in half, because a married couple, half goes to the spouse and half goes to the claimant. Well, why did we not do that? Well, all the funds of the claimant were in his name only. Well, if they're married, that doesn't matter. It's still going to be half hers and half his. The spouse was not named as a co-owner or nor a beneficiary. But that doesn't matter. They're married. These funds are joint. Because of the separation, we deposited the entire amount into the AFT. The spouse actually refused to take one half of the claimant's assets. So it's not like we didn't say, okay, we're not going to split this with you. We said, you get half of his assets. And she refused the assets. She said, no, he helps me each month. He's going to help me with the spousal allocation. I don't want half of his assets. So we have filed, and this case is still pending. We don't know how Medicaid's going to rule on this. They may make us split that money with the spouse, or they may approve it as we have presented it. So this case is an odd one. We've never had one like this before, and we are actually waiting on the Medicaid letter to tell us, or a checklist to let us know how they want us to proceed. So that was an odd case I wanted to give you and let you know that there are times when we have a spouse and a claimant, but they don't live together, nor have they for 35 years. But the spouse, the community spouse, refused to take any of his money. So this is one that I wanted to show you because it's so odd. Never happened before in all my 19 years of doing this. And so I will follow it with Sean to let him know how this case comes out. And the next time I present, this may be something that I come back to and let you know how this came out. But for now, that case is still pending.
And so I'm sorry to interrupt. Is it, I mean,
No.
it's your belief that Medicaid doesn't know what to do with this.
Well, it's our belief that Medicaid's going to come back and say, we understand that she refused these funds. So they may allow her to have the spousal support, or they may say not only does she get spousal support, but half of that money in the AFT goes to her. Since we've never come across this before, we don't know how they're going to rule. It's just that crazy of a case.
Well, Jennifer Calder says, and I agree, that it's incredible how these two individuals have such respect and compassion for each other.
And they do. They do. In fact, the son said, when they came in to meet with me, the son came in and I said, well, are your parents still friends? He goes, oh, they love each other. They just can't live together. And so they talk, they send each other Christmas gifts, they get together at Thanksgiving. They just can't live together. And they
Wow.
just never wanted to divorce.
Ms. Fontaine is asking, could any of the claimant's funds been given to trust for inheritance?
Are she talking about an irrevocable trust, or I mean a revocable trust for
I'm
inheritance?
not sure. She just says trust here, maybe to the Alabama Family Trust.
Oh yeah, these funds are in the Alabama Family Trust. And so the beneficiary named was the son because she said she didn't want any of his funds. But the son said, and he's a great guy, that he was going to use this money to take care of his mother long after his father passed.
Wow.
So the father right now is suffering from Alzheimer's, and he's not in shape yet to where he doesn't remember things, but he's just debilitated physically and cannot do he just has no way of doing his daily ADL. So that's why he's in a nursing home. But we know he's going to get worse and very quickly.
Yeah, you're racing against the clock with that.
We are. We certainly are. So our next case is a 47-year-old stroke victim. Well, in Medicaid's rules, normally you have to be 65 or older to get approved for Medicaid for long-term care. So the history of the claimant in this one is, of course, he's 47, and he's had 7 strokes within 2 months of each other. These strokes totally paralyzed his right side. He lost his ability to speak, which is just horrible. And he has weakness on his left ADLs. And so he can't get out of bed. He can't brush his teeth. He can't eat on his own. But his mind is fully there. It's just a horrible situation. So on the Medicaid planning, this is one of the harder ones that we dealt with. Claimant actually had these strokes in his 30s. So he maxed out his long-term care policy because he hadn't owned it as long as normal. You would think this would happen in his 70s or 80s. So his payout of his long-term care was not as high as normal for most people. So his claimant's power of attorney, who is actually his ex-wife, sold his business interest to pay for his care. And then she also put a lot of money into the AFT to spend down for his care. So she did the Medicaid planning correctly. She made sure that all of this was done in a way that Medicaid would approve. And so since this is a 47-year-old, Medicaid did a full review of everything. I've never had to get these records like this before. Not only were there all physician records, all hospital records, all physician notes, which are different than physician records, all nurses' notes. They wanted all CT scan records with note and a copy of all CT scan images from the strokes. They wanted all neurologist records with notes, copies of x-rays with notes, and all rehab therapy notes. The volume of information just on this page alone was several thousand pages. It was an immense amount of information that we had to gather because of his age, and we needed to prove that he actually needed the care that he was getting. So the Medicaid request for proof of assets and expenses were quite just as voluminous as the other. They wanted all business interest records. He started a business when he was 29, maybe 30, and it was extremely successful. And he also had business interest in other areas. And so we had to gather every record from the time of he was 29 of all of the businesses that he had started to the time that everything was liquidated. We had to have all the paperwork related to the liquidation of the business interest that came from attorneys' offices. And let me tell you, they didn't want to let that go. But we were able to get that. We needed proof of all care expenses. And that means that there were care expenses in the hospital that the ex-wife paid for that were reimbursed to her. The copies of all the hospital charges with payment, we had to get actual hospital billings and copies of all the payments for that. We had to get a copy of all the care logs. The ex-wife did a great job and kept care logs. She had people come in and sit with him in the hospital because he couldn't ask for anything. He couldn't do anything. So there were actually care logs kept for him. We had copies of the nursing home invoices with payment, copies of all the prescriptions invoices with payments, and copies of the daily living expenses reimbursed to the power of attorney who was the ex-wife. And so this amount of paperwork here was voluminous. It took us, we had to go through and trace on the bank paperwork every deposit from the business interest records. We had to trace it from that deposit to paying his bills and then put it into the AFT, Alabama Family Trust. And then we had to get the Alabama Family Trust to furnish us everything they had paid out with copies of the invoices that were sent into the AFT. So you can imagine the amount of work that went in just getting the paperwork ready to go to Medicaid on this one. So Medicaid sent all the asset information to the legal department for full review. They didn't even review, the worker looked at it and said, no, this is way over my head. So she sent all of that to the legal department. It took the legal department about a month to review everything. Then they sent all the medical information to the legal department for review because the legal department had to look at this, and they have physicians that they talk with to walk through everything that they look at to make sure that everything that is documented is something that would be life-changing and would send him to the nursing home, which we know it was, but they have to do their due diligence. So this took a couple of months itself for the legal department to do these reviews. We had 3 checklist letters during this process. Normally 2 checklist letters is the norm. We had 3. just an amazing amount of information. And then we did two conference calls with Medicaid. Normally you do one conference call, and that's at the beginning when you go over the Medicaid application. Well, we had another conference call with the legal department, with a supervisor, and with the worker to go through everything that I had filed to make sure that there was nothing else out there that they needed to look at. Now, the medical information was so deep, and it was just an unbelievable volume of information that they literally called in surgeons, radiologists, neurologists. They have their own, and they got them all around the table to look at these things. So the final outcome was Medicaid approval was granted. It took 6 months to get this one approved, but Medicaid went back to the date we filed and picked up all of those expenses for the claimant. So there was no more out of pocket, except for we did pay his income each month to the nursing home that that you would do. We took the $30 out per month that Social Security gives him. He had Blue Cross Blue Shield C plus along with other things because of his mental disability. He could get that, so we had those costs coming out, and so his income only was paid. And when they went through and did the calculations, they didn't even change the amount that I had calculated for the liability amount because there was no Medicare cost involved. He was too young for Medicare. They are trying to get him disability. And to my knowledge, that's going to take a couple of years.
I have
So
a question. So,
certainly
gathering those records, the business records, for example, or I mean, there's some cost involved in that.
there are.
Does Medicaid, how does Medicaid allow for those costs? Do they reimburse?
They don't reimburse, but they do allow. It's part
Okay,
of spend down. And so I think they spent a little over $4,000 in costs of getting medical records, transcripts, bank records. We had to pay paralegals for copying. So it was costly. It was costly.
I mean, it sort of makes me angry that it's this difficult.
And this is not the more difficult one that I've done. I have another one I'm going to present next that is crazy difficult too. But this one was sad because a 47-year-old,
Right.
and he's still having many strokes. So he's pretty much completely debilitated, but unfortunately his brain is just living in a dead body.
Oh,
And so they're trying to get him the computer where he can look, eye gazer, I think it's called, where they can hook him to a computer and his eyes can type,
cool.
um, so he can talk and the computer can talk. That's the next thing that they're trying to do. But yeah, this was extremely expensive on their part, and um, he's pretty much spent every dime that he's had for his care.
And so this computer program, is this a Medicaid benefit?
No, it's extremely expensive. It's, like the computer itself is like $10,000.
Okay.
But the ex-wife is going to buy that. They just have to, it's a long process for that.
Well, I mean, if nothing else, these two cases make you believe in marriage.
That would be a true statement. Yes, that is correct. That is correct. Um, and again, this ex-wife, I talk with her almost daily, and she said that that they had separate business interests, but now she is running. She bought out his interest in all of his companies, and she's running all those, and actually paying for his care with his own money from these business interests that she's running. So she is actually taking over everything for him to make sure he has care.
Wow.
So, yeah. So our next case is a 74-year-old male claimant, and he has a spouse. And the history of the claimant is that, of course, he's 74, and the claimant was diagnosed with frontal lobe dementia. Some people call that Lewy body. And he is combative. So, you can take a combative dementia patient and send them down to the Mary Harper Center in Tuscaloosa, and they do a great job with getting them on medicine that helps with that. I mean, I have told several of my clients that this would be a great thing for this client. He's very combative, and not only that, but he suffers from paranoia and he distrusts his wife. So, because of this issue, he would not appoint a POA, a power of attorney. So, right now, no one has authority at this point to take care of this claimant, not even his wife, because he's appointed no authority. So, we have to get the steps to gain this authority. And so, what we do, he cannot sign a POA at this time because of his diagnosis. So an elder law attorney must file for conservatorship or guardianship for the claimant. Now, you've heard me say before that most attorneys can file a conservatorship and guardianship. The reason I say an elder law attorney is because it's very specific in dealing with elderly than it is dealing with regular people. Um, an elder law attorney knows to make provisions for things like the Alabama Family Trust, for planning, as far as, since he's not at himself, he can do no planning at all. So there are very specific issues that elder law attorneys know to deal with that regular attorneys do not know. It's not their specialty. So I always say an elder law attorney, and we can always refer you to one if you need one. Now, excuse me, conservatorship means that the court has appointed a conservator over his finances. So they need to have someone in authority to handle his financial obligations. That is paying all of his bills and making sure that someone is accountable for every penny that he has. Because as a married couple, the couple will split assets 50-50. And so there needs to be someone from the court to say that his assets are this much and they need to be dealt with. So they do appoint a conservator. The conservatorship order must state the diagnosis of the claimant. They must state why he needs a conservatorship and what his diagnosis is for long term. They also must state um, a list of all the assets of the couple, because for Medicaid reasons, that has to be split 50-50. Half goes to the claimant and half goes to the community spouse. Um, there is a number, and I don't have that in front of me, but I think it's like 37,000 for 2025, that if the total finances is 37 or below, you don't have to do a spin down, which means the community spouse can keep everything. They don't have to do an Alabama Family Trust, but you've got to have someone, a conservator over him, to even get the information to be able to make that decision. The conservator that is appointed must file a bond in court for the assets held by the claimant. So whatever assets he owns, let's say his assets equal $130,000, there must be a $130,000 bond to cover those assets to make sure that they are done properly. Now, I also mentioned that there was a guardianship that would need to be done. Well, a guardianship means a guardian appointed over the body of the claimant. So a conservatorship is over the finances and the guardian is over the body. Well, what does that mean? Well, it means that the guardian will make all decisions related to healthcare decisions, and the guardian would make all decisions related to life decisions for the claimant. The claimant cannot sign a DNR because he doesn't have the mental capacity. The claimant cannot sign any healthcare documents. He doesn't have the mental capacity. So this guardianship gives the guardian the ability to make these decisions on behalf of the claimant. He cannot do it on his own. Any questions about that?
None so far.
Good. So, Medicaid request in this instance was a snapshot of the information gathered. Now, for a married couple, a snapshot is a sheet that I fill out, and it gives the date. It starts at the date that this individual was first hospitalized. So, we look at the date he was hospitalized, and that's the date that we get all of the financial information for the couple. So let's say that the snapshot is he was hospitalized on January 1st, and then he was in the hospital for, let's say, 25 days. Then he went to rehab, and then he went to the nursing home. Well, let's say he's got 45 days or 50 days of being in a facility. Well, he's met the 30-day minimum, number one. And number two, since he was hospitalized on January 1st, they start looking at everything in the bank account starting that day forward for the 90-day look back period. So we had to file the snapshot, which included all bank statements and everything from that date forward. And we give a total of the amount of assets on that date. So that would be a total of money in the bank, total of any investments on that date, total of any bonds or mortgages, anything like that on that date had to be listed. So then we have to file copies of the conservatorship order and the guardianship order to let them know who has the authority to be dealing with Medicaid. So this conservatorship order will let them know that they have the authority as the conservator and guardianship to deal with him with Medicaid. So we had to supply all the financial data. That financial data could also had in it everything that was spent from the date of the snapshot date forward, why that money is being spent down. You see, even though the claimant is in the hospital, his community spouse is still living. So we have to allow her to live. We have to allow her to buy her groceries, buy her gas, to live, to pay her bills. And so we have to account for that to let them know that this money is being spent properly for the claimant and for the community spouse. So we had to supply all the financial data for that. Now, the house was quit claimed to the wife, which means that this was years ago, that the doctor first told this claimant apparently that he had frontal lobe dementia. He had to make some decisions. He had to plan. Part of that planning was he went to an elder law attorney, which was a great idea. And that attorney told him to quit claim the house to his wife, which Medicaid approves. There is no penalty when you quit claim a house between a spouse, a claimant, and a spouse. You couldn't quit claim it to a child or anything like that between spouse and spouse. You can quit claim. So we didn't have to worry about that house being in his name.
I'm sorry. What does
Mhm.
it mean to quit claim?
The quit claim means to give up all of your rights to something. You stop any claim that you have on that item. So for a house, it's called a quit claim deed. And you quit claim any of your interest in the house and you give it to your spouse, which means you give up all right and title to that property. So that is not a warranty deed because it doesn't come with any warranties. It is simply a quit claim deed. And notoriously, normal real estate attorneys don't understand quit claim deeds. You have to go through a elder care attorney because they understand what this means and what it does, and it is Medicaid accepted. So you're simply quit claiming anything, any interest in the property that you have, and you're giving it to your spouse. Does that make sense?
That makes sense, but then you used another term, warranty
Uh-huh.
deed. What is that?
A warranty deed is a normal deed that you would, when you go to purchase a home, you would get a warranty deed. That warranty deed states that there are no easements, that uh, it may be a warranty deed with right of survivorship. That means that if the husband dies, the wife automatically gets 100% of the home. So it comes with warranties that the quitclaim deed does not come with. because the quitclaim deed is only quitclaiming the interest to the wife, but the warranty deed has all the warranties in it from the original purchase.
Okay. All right. Kara Loy has a question. If the quit claiming is allowed within the 5 year look back.
Yeah, it could be the day before you file.
Really?
Yes. Oh, yeah, yeah. I mean, they understand this process, and I've never had an issue with that. In fact, we were in the middle of doing this planning when we quit claimed a deed to the spouse, and I called down to Montgomery, and I wanted to make sure that we could do it, like a week before we filed, and they said, "Oh, absolutely," that they understand that this needs to be done, and it's not a problem. So you can do it up to the time you file, not after you file, but before you file.
Got it.
Now, that does not mean that there won't be, this couple did not have planning in place, so they didn't have a will. But most of the time, the Medicaid worker will ask for a copy of the will. They'll want to know who the representative is on the will, executor. They'll want to know where things are left. Why? Because if there is, if the house was not quitclaimed and is jointly owned, they're going to put a lien against the property for 50%, for his 50% or her 50% of the property owned by the claimant. And so if the deed leaves 100% of it to the wife after death, it's only after they get their lien paid. So that lien will be on the house until that house is sold. The spouse can live in that house till she dies. The spouse can sell that home, but when she sells that home, the amount they paid on behalf of the claimant will need to be paid to Medicaid out of his 50% ownership of the home.
Okay, I'm following you. So the quit claim doesn't disavow you of owing that money. It just allows you to control the interest of the house.
Yeah, that's right.
Got you.
That's right.
And Jerry John says if she predeceases him without a will, that would be a nightmare.
Oh, it would be terrible. In fact, I have sent her over to Bill Nolan and said, "You got to have a will. You cannot die without a will." And so he's doing her planning for her, and he's an elder law attorney that I use, and so he's doing that planning for her. But yeah, it is that would be a nightmare for the children, especially. So I cannot stress enough, if listening out there, do your planning and do it long before it's needed. Therefore, when it is needed, it's already taken care of and you don't have to worry about it. Um, we also had to supply copies of the caregiving expenses used from the time of the snapshot date forward because this is an elderly couple. And at the hospital, since he was, let's say, combative, there had to be somebody with him 24/7. So there had to be caregivers there, but they also sent him to Jerry Psych, and they were able to calm him down somewhat, but he's still prone to being combative. So we have to know that even though they send to Jerry Psych and they understand these issues with frontal lobe dementia, and they have medicines for that, it's very important that the nursing home that you go to keeps them on the same medicine that Jerry Site puts them on. So that's one thing I like about Mary Harper. Mary Harper will put them on medicine that translates to a nursing home. Nursing homes don't always carry all of the medicines that the Jerry Sykes carry, and and the doctor there will put them on something else that's not as strong. And so there's issues that come with that. Mary Harper can tailor a cocktail for them that the nursing home can give them to keep them settled, to keep them in a more stable um, persona so that the combativeness is calm. Now, as far as the paranoia that unfortunately comes with frontal lobe dementia. And they do have medicine for that. And sometimes it works great and sometimes it does not. So just to let you know that process there. Um, After Medicaid calculated the finances of the couple, there was no spend down needed. This couple had never saved any money. They were not financially wealthy. They literally lived from paycheck to paycheck. The house was paid for, so they didn't have a rental, didn't have a mortgage. So they literally just spent as it came in. They had very small bit in savings. I think the savings account was maybe $26,000. And then they just had their banking account. All of this was under the threshold for 2025 um, um, for the spout for the spin down for a married couple. It didn't reach the threshold at all. So the spouse got to keep all of the money they had. So there was no spin down done on behalf of this couple. There was no Alabama Family Trust needed, and so everything she was able to keep. The spousal allowance is given to the community spouse, totaling about $1,579 is what she got from his pay to get her up to the 2555 per month that she was to have for 2025. Now, we have to realize that the court, the one thing about dealing with Medicaid and the conservatorship and the guardianship, the conservatorship order had to state that she could take part of his income. So it's very important that when you do a conservatorship order, or you do a conservatorship, you have in line everything that needs to be done in the conservatorship order. You need to have it in the petition. So a elder law attorney knows this. They know that they're going to have to put in the petition that there's going to need to be a spousal allowance given from the claimant's amount. He cannot say, I want to give it. He has no authority because he's mentally incapacitated. She has no authority to sign for him saying, I want it, and he'll give it to me. She has no authority over him at this point. So this is something that has to be put into the petition for the conservatorship. So there's a list of things you need to think about when you're talking with the elder law attorney, when you do Medicaid, that you have to say, now look, down the road, this is what's going to need. We're going to need for that spousal allowance. We're going to need to approve the quitclaim deed's already been done, and they will probably want to look at that and say, yes, this is legal, and they'll put that in the order if they want to. That is not necessary, but it has been questioned before. They'll also want to say that the conservatorship, the conservator, which is actually the spouse, the conservator, has the right not only to pay bills on his behalf, but to pay bills at home. Why? He's not at home. He's in the nursing home. But his care, portion of his care is being given to the wife. So that conservatorship order has to say she can pay bills with the portion of his money. So there's a lot of things that go into the petition for the conservatorship order for Medicaid. Medicaid couldn't just give the spousal allowance. They can allow it. They can't give it unless the order says she can have it. So this is something that I've run into before when the order didn't say that. We had to go back to court and say we need a limited conservatorship order stating that she can take this much of his income to get her up to the Medicaid regs. And that's another $3,000 to get another court order. So you don't want to do that. You want to make sure you've got that on the front end when you file. So the approval was granted because on the front end, when we went to the conservator, when we sent them over to the elder law attorney, I had made a list of items, future items that she was going to need. And those future items were all listed in the petition for the conservatorship order. So when the guardian ad litem went out, who is appointed by the court over the claimant, to go out and interview the claimant, he saw that the claimant had no mental capacity whatsoever. He also saw that the spouse was living on just what they made. This guardian ad litem is excellent in Medicaid, and he understood the petition um, requests that were made. And he said, he said to the judge, yes, all of this needs to be granted, for the spouse cannot live on her income alone, which I think was $900 a month, Social Security. And so all of this was granted because 3 months before we ever got the petition filed, we had already gone in and calculated out from the snapshot date forward what would be needed, how Medicaid would respond, and what we needed. So that's how we got Medicaid approval on that case. And that case took us a while because it took 3 months to even get a conservatorship appointment with the judge to hear the case. Then it took the judge 30 days to issue the order for the guardianship and for the conservatorship. So these are things you have to think of way in advance.
So where is this gentleman the entire time this is happening? Is he
He's in
in
the
the
nursing home.
and how is
He's,
that being paid?
well, that is being paid because he's Medicaid pending.
Okay.
We know, we know that his in that I've already talked with Medicaid, and I've already sent over the Medicaid application and saying this is what we're going to be filing. We're waiting on a conservatorship order. And the Medicaid worker called me and said, okay, I got this. I understand you're waiting on the conservatorship order. So we're kind of holding on this. And I said, and the only reason I did that, I said, did I calculate the spousal allocation correctly? She goes, yes, your allocation was perfect. So he was Medicaid pending. And so we calculated the amount of the liability that he would pay each month with the spousal allowance coming out. I sent that to the nursing home with the sheet that I had that showed the allocation and how I figured it. They agreed with it, and so they took him Medicaid pending. And so Medicaid went back and paid 90 days prior, which was exactly when we filed because we knew it would take 3 months for the conservatorship. And so we had kind of planned out when to file and when to do this. And so we kind of hit the button on the head on this one.
Cassandra Hinton is asking who appoints the attorney for the patient?
The guardian ad litem is appointed by the court.
And that could literally be anyone. It could be
Well,
most often an attorney.
there are very specific qualifications for a guardian ad litem. Matthew Talley is a guardian ad litem that I deal with a lot. Matthew Talley is basically a psychologist. He he's got approval with the court. You have to go before the court and be approved by the court to be a guardian ad litem. And what that means is this person goes and interviews the claimant. He looks at the medical records and he sees that he does not have capacity and he needs a conservator. He goes back to the court and he reports that to the judge because the judge cannot get up and go interview this person. He has to have the guardian ad litem do that. And that's who this is. And they actually apply to the court to be a guardian ad litem, and they have to be approved by the court.
And is there some fee that Medicaid allows be paid the guardian and conservator?
Yes, they do. They are allowed, and that's in the court order. That's something we put in the petition that the conservator can get paid or reimbursed for any expenses, but you have to realize they didn't have any money. So what happened was that got the spousal allocation and she got to keep all of the money, but there was really nothing to reimburse to her. But a normal case of a conservator, let's say that it's not the spouse, let's say that there's just an individual let's say he's widowed, and there's a child that's going to be the conservator. Then there would be I did one where the daughter was a conservator and the court allowed her to be paid $1,500 in fees. We presented the fees to the court, things she had paid for, like copies of the checking statements, copies of the checks. And then there was a roof issue with the house, and that had to be fixed before it could be sold. And so we figured all of the cost in. It was around $1,575. We put that in a petition. the court granted that in the order. So she was paid that money back.
Roberta Fontaine says, and will Medicaid be retroactive for the 3 months the patient had been in the facility while the case was pending?
Yes.
Okay. And Mrs. Helms, Wanda Helms, asked, what happens if the pending Medicaid application isn't approved?
Ah, that's a great question. I'm glad somebody asked that. So, if it's not approved, it's either for one of two reasons. The first will be that Medicaid has 45 days to approve by federal law, they have 45 days to do approval. Well, sometimes, as you have seen in these cases I presented, it's taken months. And so they have to send a rejection letter, and then we reapply the same day. They don't lose any time, and they can continue with the Medicaid approval process. So it's not a penalty, it's just federal regulations. You have to send a denial letter after 45 days, even though we're in the middle of everything. So that's not an issue. The second reason for a denial usually is because the information that was presented did not give the answers that they wanted. And so you have to go deeper and get more information, but you have 60 days to file that, refile it. And so we usually try to refile within 20 days, at the 10 to 20 days. And then we don't lose any of the back time, and we've got it back to them, and then usually approval comes. So it really depends on the type of denial that it is. Now, we have had I had one case that was denied, outright denied, and I fired the client because we filed Medicaid. He had quite a bit of money. We put half of it into the Alabama Family Trust for his spouse. And Medicaid called me a month later and said, Ms. Strickland, do you realize that he has multiple accounts he's not reported? I said, absolutely not. I did not know that. So they gave me a listing of his accounts, millions of dollars. He did not report. So I said, please send me the denial letter. So they sent me the denial letter. I called him. This is the only denial I've ever had that I kept a denial. He came into my office and he had a Raymond James checkbook in his hand, which was not even on the list. I had never seen that. And he sat down and I explained to him why he was denied. And I said, I see you have a Raymond James checkbook. He goes, I've got millions in here and nobody knows about this. I fired him immediately. And I told him he was going to have to just private pay for his wife. I would not refile for him. And I doubt Medicaid would allow him to refile. So that was a denial. And it's my only blemish on my record in 19 years. And it made me furious. But at the same time, he lied to me. And so I fired him.
Hmm. Bonnie Elliott is asking, since Medicaid is run by states,
Mm-hmm.
could some of the rules, stipulations that you speak of
Mm-hmm.
be different elsewhere?
No, there are federal regulations and then it's state run. So the federal regulations is that you have to do it in a timely manner, basically. The state the state makes its own rules about the Medicaid applications and the approval process. But federal regulations state that has to be done in a timely manner. So that's that 45-day window that I'm talking about. That's a federal regulation. State regulations, totally different. Each state does have different. Like in California, totally different than it is here. Much easier to be approved in California. Mississippi, different than Alabama. I just filed one in Mississippi and it was different. There was a different asset limit and a different way that they allocated the spousal allowance. So each state can have different ways of instituting their own Medicaid program. I will tell you, Alabama is the strictest state in the United States.
No surprise there.
Yeah, it is the strictest state in the United States.
Lee Duncan is asking, if someone has applied for institutional Medicaid and their
Mhm.
home ends up being taken over by the bank because they failed to pay property taxes,
Mhm.
how does Medicaid handle this issue?
Well, first of all, there must be, I've had this happen actually. I've dealt with this. We had a case where a person was demented and didn't pay his bills for years. basically. And the kids were trying to take over and he wouldn't let them. There was no authority, there was no power of attorney, there was nothing. So finally the kids went in and got him got a conservatorship over the father and also got a guardianship over him. And so they went through everything and found that he had back taxes he had never paid um uh on his house. And it was up for auction. So the children went to the courthouse with an attorney. They paid all the back taxes and saved the house. The second thing that can be done is they can purchase that house for the back taxes, but you have to realize that would be a penalty to the claimant in the amount of what was not paid. So if the back taxes were $65,000 and the house is worth 150, well, you can see you've got a $70,000 penalty coming from Medicaid for that. So it's always good to get the back taxes paid and get the house back in good standing.
Miss Hinton had asked who pays the conservator.
The conservator is paid from the funds held in the conservatorship. So the conservator has to keep records of every dime spent and every deposit made into the conservator's account. He has to present this to the court every year. He has to present this to the court. So, in doing that, he has to have receipts for everything. So, the conservator can be paid for his hours, and that's appointed by the hourly amount is appointed by the court. And he can be reimbursed for anything that he spent out of his pocket for the claimant with receipts. So I mean, the court looks at this, they scrutinize this. And so that's how the conservator is paid, is from the funds held in the conservatorship. But it is limited. The court will say you can pay yourself back only X amount per month or X amount per year. And you have to go by that.
Miss Elliott asked, do all states have a family trust for spouses?
Absolutely not. That's the thing. Tennessee does not. I have a client who moved from here to Tennessee, and they didn't have an Alabama. They didn't have a trust, a Tennessee family trust, or anything like that. A Miller pool trust, basically. And so
That's what
the
I
Alabama
thought. It was a
family,
Miller Trust, just
it is the Miller
renamed.
trust. It is.
Okay. So the Miller Trust exists everywhere.
It does. It does. But the the Alabama Family Trust, which is a Miller trust, has a Medicaid payback portion of that. Tennessee does not have that. The Medicaid payback portion. But the Alabama Family Trust paid for all the expenses for the claimant, even in Tennessee.
Huh. Miss
Because once
Granger,
you set it up, as long as it's for the claimant, you can spend, you can spend it on the care.
anywhere. Miss
Yeah,
Granger asked, do you know how the proposed cuts to Medicaid are going to affect the work you do and how patients will get placed in nursing homes?
that's a great question, and that's still up for debate. Right now, it's not affecting anything, but I don't know, and I worry about that, and I'm trying to research that. And what I'd maybe Sean, maybe the next thing we do is a seminar on the Medicaid cuts and what's going to happen and how it's being done.
That'll be
Um,
good.
that would be a good seminar, but that is something I'm researching right now. It's not affecting me, not affecting my clients, but that doesn't mean it won't.
The Ms. Taylor is saying, in the case of non-paid property taxes, who will be held responsible for the remaining balance?
The claimant.
All right, it's we're against the hour. Our password today is planning, capital PLANNING. Our evaluation link, I'll read for you again if you're watching this online. It's https:// www.surveymonkey.com/lowercase r/ all uppercase letters and some numbers. C is in cat, Q, W, S is in Sam, 6, 7, C is in cat. and we'll have you back again. Pam, we always like having you here.
Thank you.
The
I
link
enjoyed it.
I've posted again in the chat room for y'all. So many good comments. Thank you for being here. Y'all join us again on Monday, June the 9th, when Bill Nolan, who Pam mentioned, will present to us what your retirement or what your financial planner doesn't tell you about retirement. So Monday, June 9th at noon via Zoom. Join us again. Thank you for being here today. The password is planning with a PLANNING. The CU code word is planning, Miss Stevens. Thank you, Mr. Bryan, and thank you all. Thank you, Pam, so much.
You're
Y'all
welcome.
have a
Thank you.
great day and a great week, and we'll see you in a couple of weeks.